All the deceased were innocent and did not deserve to die in the manner that they did. I now deal with the specific offences that the accused were convicted of. Firstly, POCA. Section 1 of POCA provides that any person convicted of an offence referred to in Section 1 shall be liable to a fine not exceeding 1,000 million rands or its imprisonment for a period of up to life. There should be a balance between the sentence imposed on the predicate offence and the sentence imposed in terms of the racketeering provisions. If the enterprise has been established to commit serious offences, participation in the activities of the enterprise must therefore be viewed in a more serious light than the predicate offences itself. The sentence received on the predicate offences should correlate with the sentence imposed on the racketeering offences. The racketeering charges are the more serious, as it was a business of the enterprise to kill people. That is why the legislature in Section 3, subsection 1 of POCA provided for sentences of life. In this regard, see State v. Prinsloo and others, 2016, Volume 2, SACR 25, in the brackets SCA, and State v. Nosofar, 2018, JDR 2239, in the brackets GJ. Many of the predicate offences attract the maximum sentence. It follows that the maximum sentence should be imposed in respect of the racketeering offences. It also follows that should an accused be sentenced to life imprisonment on a predicate offence, that the same offence should also be imposed in respect of the racketeering offence. In respect of accused 3, she should also be sentenced to a similar sentence in line with the predicate offences committed after 21st October 2015. Life imprisonment is therefore applicable. When it comes to count 3, which is intimidation, Section 27(1)(c) of Act 26 of 1956 determines a sentence of not less than 3 years and not more than 15 years, where the causing of danger to life or property is willful. This was the exact situation. A sentence of 8 years imprisonment is an appropriate sentence in these circumstances in respect of accused number 1 and 2, and in respect of accused number 3, having regard to her age, an appropriate sentence would be 5 years imprisonment. When it comes to count 4, which is the causing of an explosion, Section 27(1)(c) of Act 26 of 1996 determines a sentence of not less than 3 years and not more than 15 years. Let me repeat this. Section 27(1)(c) of Act 26 of 1956 determines a sentence of not less than 3 years and not more than 15 years where the causing of a danger to life and property is willful. Once again, this was the exact situation. A sentence of 8 years would be an appropriate sentence for accused number 1 and 2. In respect of accused number 3, having regard to her age, an appropriate sentence of 5 years imprisonment should be imposed. When it comes to count 5, which is the malicious injury to property, more than 3 vehicles were damaged due to a detonation of the explosive devices. During 2012, the cost of repair of the vehicles of Latham, Vrede and Groenewald amounted to approximately 13,500 rands. An appropriate sentence of 3 years imprisonment for accused 1 and 2 is applicable. In respect of accused 3, having regard to her age, an appropriate sentence would be 1 of 2 years imprisonment. When it comes to the murder charges, namely counts 6, 7, 8, 9, 11, 12, 21, 24, 27, 29, in terms of Part 1 of Schedule 2 of the CLAA, read with Section 51(1), a sentence of life imprisonment is prescribed for murder where it was planned or premeditated. The death was caused during a robbery with aggravating circumstances, or where the offence was committed by a group of people or a syndicate in the furtherance of a common purpose of conspiracy. All the murders were carefully planned and premeditated, and executed in furtherance of a common purpose or conspiracy or group of people, and in this case, electus Budaeus enterprise. All the murders fall under Part 1 of Schedule 2 of the CLAA and are therefore liable for sentence of life imprisonment in terms of Section 51(1) of the CLAA. Life imprisonment would be an appropriate sentence for accused number 1 and 2. In respect of accused number 3, the appropriate sentence for counts 8 and 9, committed prior to 21st October 2015, is 15 years imprisonment. And for counts 11, 12, 22, 24, 27 and 29 committed after 21st October 2015, life imprisonment would be applicable. When it comes to the robbery charges, namely counts 13, 23, 25, 28 and 30, in terms of Part 2 of Schedule 2 of the CLAA, read with Section 51(2), a sentence of 15 years imprisonment is prescribed for robbery where there are aggravating circumstances or involving the taking of a motor vehicle. Aggravating circumstances in relation to the robbery means the wielding of a firearm or any other dangerous weapon. All the robbery charges involved the wielding of a firearm during the execution of the robberies and fall squarely under the ambit of aggravating circumstances. The prescribed minimum sentence of 15 years imprisonment should be imposed. Dealing with count 10, which is the conspiracy to murder, it is clear from the evidence led that the colluded crime was murder, and this court is entitled to impose an appropriate sentence as if it convicted on account of murder. The provisions of the CLAA are not applicable. This was an elaborate conspiracy consisting of many scouting expeditions under false pretenses, obtaining personal information from Joshua Groenewald, doing a dry run, obtaining the services of assassins and providing them with firearms, digging of graves to dispose of the body. Extensive surveillance was conducted at his workplace, his home, as well as his sporting venues. The conspiracy in this instance entailed the most extensive and thorough preparations of all the murders. They did everything in their power to execute the plan. The only reason they did not follow through was due to Jakes de Villiers' unexpected and untimely disappearance. Had it not been for this fact, there would have been another murder. In my view, an appropriate sentence for accused 1 and 2 should be 14 years imprisonment. In respect of accused 3, having regard to her age, an appropriate sentence would be one of 7 years imprisonment. When it comes to count 19, which is a fraud on discovery to the amount of 3.57 million rands, the fraud charge attracts a minimum sentence in terms of Part 2 of Schedule 2 of the CLA, since it involves an amount of more than 500,000 rands, and it's proven that it involves an amount of more than 100,000 rands. And if it was proven that the offence was committed by an enterprise in the furtherance of a common purpose or conspiracy, in the absence of substantial and compelling circumstances, the prescribed minimum sentence is 15 years imprisonment. And accused 1 and 2 should also be sentenced to 15 years imprisonment. Counts 14 to 18 and 20, which is the various fraud charges and defeating the cause of justice. All these counts are the so-called secondary offences in order to achieve the successful payout of the fraud at discovery, in brackets count 19. An appropriate sentence would be one of 2 years imprisonment on each of the counts in respect of accused number 1 and 2. Counts 26, which is the fraud, an appropriate sentence of 2 years imprisonment would be appropriate for accused number 2 and 3. Which brings me to count 31, which is the illegal possession of firearms. The minimum sentence in terms of Part 2 of Schedule 2 of the CLA is 15 years imprisonment for any offence relating to the possession of an automatic or semi-automatic firearm. 3 of the firearms which the accused were convicted for possession of are semi-automatic firearms. 15 years imprisonment in the absence of substantial and compelling circumstances is an appropriate sentence. Count 32, which is the illegal possession of ammunition. It's clear from the evidence that a vast number of ammunition was discovered at Kosana flats, as well as in the classroom of Marinda at Jan de Klerk Secondary School. An appropriate sentence would be 3 years imprisonment for all the 3 accused. It is right that a court must consider the cumulative effect of a sentence and reduce the total of period of imprisonment so that it is proportionate to the total moral blameworthiness of the perpetrator. In State versus Motswatupa, 2012, Volume 1, SACR 259 SCA, at paragraph 8, at page 263, it was held that a court must not lose sight of the fact that the aggregate penalty must not be unduly severe when dealing with multiple offences. It is right that sentencing courts in all the divisions of our courts have been enjoined to have regard to the nature of the offences and where there is a close connection or similarity between the offences involved, or where there is a close connection in time and place and intention with regard to the offences involved, then usually the counts are taken as one for purposes of sentence, or the sentences are ordered to run concurrently. In the present case, there is an overlap only in respect of counts 3, 4, and 5, and counts 11 and 12. But all of this is academic, since the main sentence is one of life imprisonment. Could accused number 1 stand up, please? Number 1. Taking all the above into account, the following are the sentences which I impose on you. Count 1, racketeering, life imprisonment. Count 2, intimidation, 8 years imprisonment. Count 4, causing an explosion, 8 years imprisonment. Count 5, malicious injury to property, 3 years imprisonment. Count 6, the murder of Natasha Berger, life imprisonment. Count 7, the murder of Joy Bonzaya, life imprisonment. Count 8, the murder of Reginald Ben Dixon, life imprisonment. Count 9, the murder of Michaela Valentine, life imprisonment. Count 10, the conspiracy to commit murder of Joshua Valentine, 14 years imprisonment. Count 11, the murder of Peter Meyer, life imprisonment. Count 12, the murder of John Meyer, life imprisonment. Count 13, robbery with aggravating circumstances, 15 years imprisonment. Count 14, theft, 2 years imprisonment. Count 15, fraud, 2 years imprisonment. Count 16, fraud, 2 years imprisonment. Count 17, fraud, 2 years imprisonment. Count 18, fraud, 2 years imprisonment. Count 19, fraud, 15 years imprisonment. Count 20, defeating the cause of justice, 2 years imprisonment. Count 21, the murder of Count 21, the murder of Jared Jackson, life imprisonment. Count 31, possession of an unlicensed firearm, 15 years imprisonment. Count 32, possession of an unlicensed ammunition, 3 years imprisonment. In terms of Section 280, subsection 2 of the Criminal Procedure Act, it is ordered that the sentences in counts 3, 4, 5, 10, 13, 14, 15, 16, 17, 18, 19, 20, 31, and 32 are to run concurrent. 3. Ex lege, these sentences will run concurrent with the life sentence. In terms of Section 39(2)(a)(1) of the Correctional Services Act, 111 of 1998, all sentences to be served will run concurrently with the life sentence. In terms of Section 39(2)(a)(2) of the Correctional Services Act, all life sentences are to run concurrently. You can take a seat. Number 2, taking all the above into account, I impose the following sentence on you. 1, racketeering, count 1, racketeering, life imprisonment. Count 2, managing an enterprise, life imprisonment. Count 3, intimidation, 8 years imprisonment. Count 4, causing an explosion, 8 years imprisonment. Count 5, malicious injury to property, 3 years imprisonment. Count 6, murder of Natasha Berger, life imprisonment. Count 7, murder of Joy Bonzire, life imprisonment. Count 8, murder of Reginald Ben Dixon, life imprisonment. Count 9, murder of Michaela Valentine, life imprisonment. Count 10, conspiracy to commit murder on Joshua Groenewald, 14 years imprisonment. Count 11, murder of Peter Meyer, life imprisonment. Count 12, murder of John Meyer, life imprisonment. Count 13, robbery with aggravating circumstances, 15 years imprisonment. Count 14, theft, 2 years imprisonment. Count 15, fraud, 2 years imprisonment. Count 16, fraud, 2 years imprisonment. Count 17, fraud, 2 years imprisonment. Count 18, fraud, 2 years imprisonment. Count 19, fraud, 15 years imprisonment. Count 20, defeating the ends of justice or the cause of justice, 2 years imprisonment. Count 21, murder of Jared Jackson, life imprisonment. Count 22, murder of Glenn McGregor, life imprisonment. Count 23, robbery with aggravating circumstances, 15 years imprisonment. Count 24, murder of Anthony Schofield, life imprisonment. Count 25, robbery with aggravating circumstances, 15 years imprisonment. Count 26, fraud, 2 years imprisonment. Count 27, murder of Kevin McAlpine, life imprisonment. Count 28, robbery with aggravating circumstances, 15 years imprisonment. Count 29, murder of Johanna Lateghan, life imprisonment. Count 30, robbery with aggravating circumstances, 15 years imprisonment. Count 31, possession of unlicensed firearm, 15 years imprisonment. Count 32, possession of unlicensed ammunition, 3 years imprisonment. In terms of Section 280, subsection 2 of the Criminal Procedure Act, it is ordered that the sentences in counts 3, 4, 5, 10, 13, 14, 15, 16, 17, 18, 19, 20, 23, 25, 26, 28, 30, and 31, and 32 are to run concurrent. Ex lege, these sentences will run concurrent with the life sentences. In terms of Section 39(2)(a)(1) of the Correctional Services Act 111 of 1998, all sentences to be served will run concurrently with any life sentence. In terms of Section 39(2)(a)(2) of the Correctional Services Act, all sentences are to run concurrently. You may take a seat. Accused number 3. Taking all the above into account, the following are the sentences which I impose on you. 1, racketeering, life imprisonment. Count 3, intimidation, 5 years imprisonment. Count 4, causing an explosion, 5 years imprisonment. Count 5, malicious injury to property, 2 years imprisonment. Count 8, murder of Reginald Ben Dixon, 15 years imprisonment. Count 9, murder of Michaela Valentine, 15 years imprisonment. Count 10, conspiracy to commit murder on Joshua Groenewald, 7 years imprisonment. Count 11, murder of Peter Meyer, life imprisonment. Count 12, murder of Joan Meyer, life imprisonment. Count 13, robbery with aggravating circumstances, 15 years imprisonment. Count 22, murder of Glenn McGregor, life imprisonment. Count 23, robbery with aggravating circumstances, 15 years imprisonment. Count 24, murder of Anthony Schofield, life imprisonment. Count 25, robbery with aggravating circumstances, 15 years imprisonment. Count 26, fraud, 2 years imprisonment. Count 27, murder of Kevin McAlpine, life imprisonment. Count 28, robbery with aggravating circumstances, 15 years imprisonment. Count 29, murder of Johanna Lateghan, life imprisonment. Count 30, robbery with aggravating circumstances, 15 years imprisonment. Count 31, unlawful possession of firearms, 15 years imprisonment. Count 32, unlawful possession of ammunition, 3 years imprisonment. In terms of Section 280, subsection 2 of the Criminal Procedure Act, it is ordered that the sentences in counts 3, 4, 5, 10, 13, 14, 15, 16, 17, 18, 19, 20, 31, and 32 Just 1 second, please. Let me repeat this. In terms of section 280, subsection 2 of the Criminal Procedure Act, it is ordered that the sentences in counts 3, 4, 5, 10, 13, 23, 25, 26, 28, 30, 31, and 32 are to run concurrent. Ex lege, these sentences will run concurrent with the life sentences. In terms of section 392A1 of the Correctional Services Act 111 of 1998, all sentences to be served will run concurrently with any life sentence. In terms of section 392A2 of the Correctional Services Act, all life sentences are to run concurrently.
Please report on the law. The statement also does require from the court to make an order for forfeiture of the exhibits, the firearms, the illegal firearms, and you've prepared a draft order for your consideration.
Yes. Ms. Nell, have you seen the draft order?
We have the contents, my lord, and there's no objections from the side of the accused.
Ms. Johnson?
My lord, there's no objection from the accused to as well as accused.
You've got instructions from Mr. Kusa? Yes. What would this exhibit be?
That would be...
It's not really an exhibit.
No, it's just part of the proceeding. It's just a court order.
Yes, should I just read this into the record or just indicate that the draft orders made an order?
As it would be.
The draft order marked, let me repeat this. The draft order marked X is made an order of court.
As a pleasure of court order. That is the roll.
This court is adjourned.
Before we adjourn, there's one other issue which the court hasn't addressed. It's the fact that accused number 3 is still being kept at the John Foster with the Johannesburg Central Prison. I mean, cell.
Yes.
What would happen to her at this point?
I don't know. Once a person has been sentenced, she must go to the correctional center. But of course, I think Mr. Roberts, there was some concern that accused number 3 had indicated. And I think if you recall, Mrs. Skippers had testified that Miranda Steyn had said that once accused number 3 gets sentenced, they will take care of her.
That is correct, my lord. That was the evidence before court. The only thing that the court might consider is to make an order that she not be kept in the same facility as where the other Miranda, her mother, as well as accused 2 is being held. But that is primarily a function of the correctional services.
So I can't really. Obviously, I think the impression I think that I got was that if she goes to the same facility, Miranda will make sure that she's taken care of.
That is the evidence.
And it's something I think that I can't ignore that.
Indeed.
I can't also prescribe to can I prescribe to the facilities as to what should happen?
No, but the court can make a strong suggestion to the prison authorities that in the light of the evidence before you, that they should seriously consider not keeping them in the same facility.
I remember, I think the last time you'd indicated to me that if she was to be sent to Pretoria, there might be some traffic delays. Do you recall that discussion I think that we had?
That was during the trial. That's correct, my lord.
And is there a possibility still that she be kept at a different centre?
Indeed, my lord. That can be arranged, but I think the court must just make an observation to that as well.
Obviously, I've indicated that a previous witness, Mrs. Skeepers, had testified that should accused number 3 be sentenced and she's sent to the facility that she's currently held at, the steps will be taken to have her taken out. And the impression I think that I got was that she will be eliminated. I sincerely hope that the state will ensure that the claims made by Mrs. Skeepers will be investigated, and that it can't be that anyone is above the law, and that includes, I think, Miranda. But of course, I think, we've not heard, I think, her side of the story. But it's something I think that needs to be investigated by the relevant authorities. Due to the concern that I have, and due to what Ms. Skeepers had testified to, I would strongly recommend that accused number 3 be kept at a different facility to the ones where her mother, Miranda, is currently being kept.
As it pleases the court, my lord.
Yes.
We'll follow that.
Anything else? This court is adjourned.
Yes.